Have anybody gifted you any item before and you didn't collect what is called deed of gift? Especially when it comes to the case of car, land, houses, and you didn't collect what is called deed of gift. I'm telling you, I'm making a major mistake that may cost you, and a little mistake that you commonize may cost you a lot. My name is Joseph, your lead consultant of Global Dealers Properties. Now, today, we will be looking at what is called deed of gift. Now, what is deed of gift? A deed of gift is a legal document that shows the transfer of ownership of movable and immovable items like real estate properties, lands, cars from one person to another. And these items can be presented as a gift during birthday, anniversary, can be marriage ceremony, can be during a birthday or a company anniversary. So depending on the particular occasion, a gift can be presented to you. Now, they are of two types. We have two types of deed of gifts. We have the revocable deed of gift, and secondly, the irrevocable deed of gift. Let's look at one after the other. One, the revocable deed of gift. It's a type of deed that can be revoked at any time as long as the gift is still in the hand of the recipient. The donor has a right to revoke it back. That is why it is called revocable. Now, the recipient on this case is the receiver, while you that is gifting the property is called the donor. So long as further gifted item is still in the hand of the recipient, the donor can still take it back when issues come up tomorrow, or maybe there is dispute, or two of you are no longer in a relationship again. That donor can come back and say, I want back my gift, and he or she has a right to collect it back from you, so long as far what you gave him initially was the revocable type of deed of gift. Secondly, the second type of deed of gift we are looking at is the irrevocable deed of gift. So unlike the first one, this type of deed of gift, the recipient, which is the receiver, have full ownership over the asset, and in this case the donor cannot revoke it back, or which is cannot take it back from you, because it is called irrevocable as the name implies. So even if in the case of marriage, maybe in the case of relationship, the husband and the wife are no longer in the marriage, they have quarrel or they have fight, and the husband initially gifted the wife a housing property or a land, and he now recall that, okay, since I'm no longer in good relationship with this my wife, okay, and that party cost me a lot, let me go and collect back my gift from her. But if what he gave to her as a document for that land or for that house is this type of gift, deed of gift, which is the irrevocable, you can no longer collect it back from her. That is why it is called irrevocable. Before the court of law, you don't no longer have the right, because you have already conferred on her, on the person, a full ownership over that asset. So that's why it is called irrevocable deed of gift. Now, there are some basic elements to look at when it comes to deed of gift, and some of the basic elements that must be included when giving a deed of gift include: one, the name of the donor and the recipient must be written in it, their address and their relationship status, and their relationship, which is the kind of relationship that they have. Are they brothers? Are they sisters? Are they relatives? Is it husband and wife? Is it my brother? Is it my cousin? So the kind of relationship between you and between the donor and the recipient must be clearly stated. Second element of this deed of gift include the donor's intent. The donor's intent. So on this case, the donor must state clearly that he or she is giving you this gifted item voluntarily, out of love, without any force or be threatened or be manipulated to do it. So he or she must be in a clear state of mind to ensure that he is giving this property from his own free will without being threatened or be forced to do it. Thirdly, the property details. These property details must include the layout. In the case of a land, for instance, now, it must include the layout of the land, the measurements, must the layout of the land, the boundaries, the coordinates, and all the full information of the land must be contained on it. And fourthly, a witness must be there, like a third party, to be a witness that, okay, I was there when this party was gifted from Mr. A to Mr. B. I was there, I'm a witness to this transfer of ownership. So it's a third party eyewitness. And fifthly, the acceptance of deed, which is the last element of this deed of gift. Is called the acceptance of deed. The acceptance, in this case, both the donor and the recipient must sign on it and were dated. So, because when you give the recipient the property or the asset, he or she must also write back, okay, that he is receiving, because if he or she did not receive it, there's no way it's going to fly. So the recipient must also write back that is receiving this gifted item from you with so clear mind as well. So I know, yeah, we must have find this video helpful in one way or the other, that in the case if perhaps before now somebody has gifted you a housing property, a landed property, and you just carried away or be excited out of that experience and you did not ask for the person, please do so